Hey guys, how you doing?
Good, Clint. How about you?
Hanging in there. Another day.
Rocking the beard there, Ben, I see.
Yeah, I figured this is my only opportunity to ever do that.
Might as well.
Good morning, gentlemen. How are you all?
Very good.
Morning.
Morning.
Good morning.
Your
Good
Honor.
morning. Good morning. This is cause number 18-97. Will reflect that the parties are appearing via Zoom today on the defendant's motion for leave to file the first amended third-party petition. I believe, Mr. Eccles, this is your petition, correct?
Correct.
Your motion?
Right.
Okay. And we'll just caution the parties that we are streaming live to YouTube today, so make sure that you don't divulge any sensitive information from your clients or personal identification matters to the public. So, Mr. Eccles, it being your motion, are you ready to proceed?
I am, Your Honor.
All right.
I think the motion is fairly
Go ahead.
self-explanatory. And again, Judge, I don't know how familiar you are with the case, so I'll just be very brief about the background. Case involves
I'm fairly familiar.
Okay.
Yeah, we've had a couple of hearings on this, probably before you were involved. If my recollection.
Yeah, I think I had somebody else attend, but yeah, right, fair enough. This is an insurance case, and the fact that the insurance carriers in this case, who have not appeared and are not parties, aren't paying or didn't pay what the plaintiff thinks should have been paid under a claim that was made. The policies in question are rather unique. They have to do with race cars, both on track and off track. Apparently, and you learn something new every day, those aren't off the rack type policies you can go get. They are somewhat unique, and sometimes you can't get them at all, depending upon the date, the time, etc. The policies that we're talking about in this case were a concept brought up by NAMA, North American Motorsports Association. They sponsored it, they put it together, and they created through other parties a master policy to which it was NAMA, the named insured. It then allows other people to essentially tag along on that policy by issuing certificates. You apply for it the same way, just like Mr. Scott in this case did. It's all through an online portal, but the bottom line is that NAMA is the one that then issues these certificates to allow the people to be insured on that master policy. My client, who was the agent, had no clue that's how that operated. We didn't find out exactly how that worked, or I say exactly, mostly understanding what happened until we took the representative deposition of IOA a month and a half ago or so, before this motion was filed. So once we figured out that NAMA was, for lack of a better term, one of the culpable insurance type parties in the case, we needed to bring them in, especially in a case like this where we're having difficulty joining or bringing in Capital Security or Motorsports Insurance Group, who are kind of the insurance entities, the underwriters. One of them is anyway. So long story short, we filed this motion to join NAMA as a party. One of the theories that the plaintiff has come up with in terms of liability has to do with under the insurance code. If you assist in procuring an insurance policy from a foreign insurer who then denies that policy or denies coverage, et cetera, then you are also potentially liable. So NAMA is equally responsible under that theory, given their participation in approving and issuing the policies in question. As a side note, and again, I think this impacts this. I know that we're technically have a November trial setting. I don't think that any of the parties have an issue with moving that setting by virtue of bringing in new parties. We've talked about that, but I don't want to speak for the other parties on that. If I'm misremembering that, I want them to tell me. And the last issue is the reason why that's important, Your Honor, is we've in our prior third-party petition, just like the plaintiff did, we attempted to bring in Motorsports Insurance Group, or MIG, and Capital Security. We were unable through the Hague Convention to get them served because they're in Bermuda, and Bermuda stopped accepting mail from the US until about a week and a half ago. So we're now taking steps again to go through the Hague to get them served and bring them into the case. Whether they appear or not, I don't know, but I need to go through those steps. So long story short is I don't think there's any prejudice in bringing in any parties at this point because we're still doing that. So that's the short version, I guess, of everything.
Okay, good. And after I hear from Mr. Cates, and is it Weibel?
Yes, Your Honor.
Weibel, okay. After I hear from them, we'll discuss that November setting. We're getting some word from the Supreme Court, I believe, either end of this week or next week regarding trial setting. So we'll talk more about that. But
Sure.
Mr. Case, do you have any objection to the motion to leave to file the amended petition?
No, Your Honor, my client does not object to it.
I didn't think that you did, but wanted to make sure. And Mr. Weibel?
Yes, Your Honor. We don't have any specific objection, only with respect to Capital Security and to MIG. Obviously, they're already listed as defendants and are arguably a culpable parties. However, my client, Insurance Offices of America, cannot agree to bringing in NAMA. NAMA is actually my client's client. And therefore, since we performed merely administrative duties with respect to the policies, our client just can't agree to have NAMA brought in as a defendant, especially at this late stage of the game.
And can you give me some more explanation on exactly what kind of entity NAMA is? I think from what Mr. Eccles had stated, I had kind of an understanding that they were an organizer of policy, but are they an insurer as well?
No, Your Honor. My understanding is that they're an organization that that actually involves drag racing and that the whether or not Brainchild is an accurate characterization, I don't know. But at the same time, they do assist in the sport and they advocate for that. But they are not, in fact, an insurer. They are, as Mr. Eccles described, it's kind of a complicated setup, but they are the named insured on the main policy, and then the other insureds, other drag racers with equipment and cars can apply to be a part of that policy, but NAMA is not, in fact, an insurer itself.
Okay, that helps me. Okay, all right then. The court then there being no objection, at least from the plaintiff in the case, court is going to grant Eccles' motion for leave to file the first amended third-party petition. Court will grant that, Mr. Eccles. Regarding the November setting, and I believe that was November, is that right?
November 20.
November 20?
Yeah.
I think Halloween. I think Thanksgiving this year is later in the month. So just to kind of have a discussion about where we are. I attended a couple days of training this week with my judicial entity, and we expect the Supreme Court to issue their guidance on the selection of jury trials. OCA, Office of Court Administration, has already issued their recommendations. We expect the Supreme Court to either adopt those, modify those, or abandon those. We anticipate that they're going to adopt those, as they've adopted just about everything that OCA has recommended after the Supreme Court and Court of Criminal Appeals had deferred to OCA and requested that they undertake the issuing of guidelines regarding public safety measures with compelling a body of an hour member to come in and try cases. So we expect probably either tomorrow or early next week that we should hear something from the Supreme Court. Right now, what we are allowed to do is each court that wants to try a case, and it's going to be limited to district courts and county courts and statutory county courts of law, have to submit a trial plan laying out the steps and safety precautions, procedures, and how we're going to bring in a panel, how we're going to conduct the trial. And that has to be approved by the local administrative judge, which in Van Zandt County is me, but it also has to be approved by the regional judge. And for me, that is Judge Alfonso Charles in Gregg County. Once that is approved by us, then it goes up to the Office of Court Administration. And then if they approve, then we're given the green light to select a panel and bring them in. Right now, we're and that begins October 1st. We can begin that October 1st, and that extends through December 31st, unless that's modified by Supreme Court order this week or next. Anticipating that that will remain the same. What we're doing here in Van Zandt County is we are attempting to put together our plan and get it submitted. We have not done that. We weren't sure that we were going to be able to even have a case before the end of the year, so we didn't start jumping through hoops and trying to acquire civic centers and things of that nature, which is what the plan is going to require. It's going to be an off-site voir dire panel, 6-foot social distancing, microphones, the whole setup. So rather than start jumping through those hoops back in the summer, we wanted to wait to see what the likelihood was that we would actually be trying a case. So right now, I met with other county leaders last week to start planning what we can do, what we're capable of doing here in our small county. And right now we're looking at bringing in a panel on October 26th. If our plan gets approved, it's a retrial of a sentencing case that went up on appeal and came back in the criminal case. And so that's going to be our first foray into a COVID trial, so to speak. And if that goes well, then we may be able to have another panel or two in November, but it's probably not likely. I tell you all of that to give you the buildup that it's probably not likely that we're going to reach any civil trials the rest of this year. I would anticipate the next 2 or 3 are going to be criminal trials of those who've been incarcerated for a year or longer on the priority schedule. So I'm assuming that with your amended petition and still trying to get MIG and Capitol Security in, that you all anticipate your trial setting to be continued as well. Is that correct?
Certainly I am.
Yeah, I mean, is that what y'all were anticipating as well, was to delay until you can get these two other entities brought into the case?
Again, for me, yes, that's exactly what I was anticipating.
And I'm not sure, Your Honor, just based on the history of the case, that MIG or Capital are ever going to respond, frankly. But certainly NAMA might join in, and at that point, obviously everybody has a little bit of discovery to do in the case. So. Okay.
All right. So I just want to give you all that heads up that, I wouldn't start working really hard to meet a November trial, but at the same time, I hadn't sent notice out yet because I haven't been given any direction from the Supreme Court. So what I've done is just kept all my settings the same, and not sure, not knowing if the Supreme Court was going to lift all requirements, and if we could just start bringing panels back in like we did in the before days, then no problem in doing that. But obviously there's a lot of hoops that we're going to have to jump through, and we're going to do off-site fire and a civic center most likely is our plan, and then we can reconfigure the courtroom. Have any of you gentlemen tried a case during COVID?
No, Your Honor.
Only in JP court.
Only in JP court? Okay.
Yes, Your Honor.
So I know there was about 20, they did about 20 test trials throughout the state. That really is what has created our guidelines. And so I didn't know if any of you gentlemen had done that. Obviously the larger jurisdictions have more resources and more ability to go off-site. And so here, that's what we're going to have to do as well. And so once that trial plans gets put together and approved, then we try a couple of these criminal cases, October and November. I think we'll have a real steady outlook on what we can expect come January. And I think we will start ramping up our trials and trying to get rid of some of this backlog that has built up. And obviously this case would be one of them that's going to have the priority. So based on what your setting has been in the past, we're going to give that same preference. We're just going to try to shift everything, and those who were put off during this time, we're going to try to put them right back into their priority slots to get you guys resolved. So I don't want you to think that we're going to push you off a year. That would not be our plan, but we are going to have to stick our toe in the water and figure out, how to try these cases and get our citizens in to serve on the jury. So once we do that, by Thanksgiving, I should have a real firm understanding of what we're capable of doing. And if we were able to pull this off on these criminal cases, then what my expectation would be is January into the spring is start slating these cases, and your case would be in there, unless you I'll reach an agreement or there's other delays in the case that you bring to my attention.
Sounds good.
All right. Anything else,
Good.
gentlemen?
I don't believe so, Judge. I'm fairly certain I submitted an order with that.
Yes, I was going to ask you, I'll check. If not, then I'll just have my coordinator email you and you can, you can just email her a proposed one or you can e-file one, but I'll have her notify you. I think that you did. And I think I've just kept it in my queue waiting for today's hearing.
Okay, cool.
All right. Well, gentlemen, I appreciate your patience this morning and I look forward to seeing you again.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
You're very welcome.